And I just want to make sure everyone's able to view the captions. And I'm going to put a message out on chat too. Just wanted to be sure everyone's able to see the interpreters, see the captions if they need to. To access the captions, go to Live's transcript. It says CC on my end. It's on the right at the bottom. I just want to make sure everyone can see it. Thank you, Anna. She said, I can see captions. And we'll go ahead and start in a second. I just want to make sure for the people that aren't here right now are able to view the accommodations that they need. So we'll go ahead and get started. Thank you for everybody who's attending tonight. Thank you, Ed, for joining us tonight. My name is Angelica Dill. I'm one of the co-founders of Adjacent Space. Trey Gordon is also a co-founder of Adjacent Space who's with us tonight. We've kind of tag teamed each session. And now we're finally here together doing the session tonight. This is 3 out of 4 sessions that we've been doing. We broke down the ADA into 4 different parts. There's 5 titles, but we decided to kind of focus in on a few topics that seemed like it was something that should be addressed specific to our community. And tonight is about public accommodations, Title 3. So better business, public accommodation, accessibility in businesses, and the rights of customers. So we're all customers of something, right? We all receive services. We are consumers of lots of things. We're out in our society doing things. So public accommodation kind of covers a wide gamut of areas, and it has a lot of nuances as what I've discovered as not only an interpreter, but an advocate and an ally. You know, as I'm navigating as that role, it's a little bit challenging even for me to sometimes figure out the nuances and the gray areas of that. But just to briefly talk about Adjacent Space for a moment, we're a nonprofit based out of Birmingham, Alabama, and our mission is to seek equity and accessibility through various forms of action. So sometimes we're retroactively advocating or responding to something that's happened in the community. We've done a lot of different projects in the community. One year it was seeking out clear masks and, you know, passing that out to our community when there was a mask crisis. And another time we had been noticing a trend with funeral homes and a lack of accessibility there. So we started writing up a letter that's now on our website that we decided to also send out to all the funeral homes in Alabama. So there's a few different things that we've done when we've noticed some trends. We also try to create our own kind of change. We've hired a lot of deaf interpreters to interpret our website. We want to be a model of accessibility and equity as much as possible. And so you'll see that it's not just interpreted information, but it's, you know, side by side English and then ASL. And we do that also, we reflect that on our social media as well. So a lot of cool things that we've done with our funding. We appreciate all of the grant support and the personal donations from our community. It's really made a difference, and we've really tried to impact in all the ways that we can. So tonight is one of those proactive action things where we're using education to talk about what the ADA says and try to create empowerment or just start some conversation around it and kind of discover some things together. So at the bottom, you'll see a place to chat. Please feel free to add comments along the way. If you have a question at any time in the middle of all of this, you're welcome to ask it on video. We can toggle some things and change it so that you can be on video with us, and we'll have an interpreter ready. It doesn't matter if you're a hearing person or deaf, whatever mode of communication you're using, we have an interpreter ready for that as well tonight. And so we want everyone to either feel comfortable asking something in the Q&A portion. You can, write comments in the chat, or asked to join the call for a moment to ask your question. So again, please do that anytime. First, before we introduce each other, I wanted to ask who everybody is in the audience, if you don't mind in the chat, putting maybe where you're from, if you're a hearing interpreter, a deaf interpreter, if you're a deaf community member, if you own a business, just kind of any piece of information for us to get a pulse of who's out there. Panelists, audience members, whoever. Trey, if you want to go ahead and introduce yourself, and then Ed, and then Trey will take us off with some questions.
Sure. Yes, thank you for that wonderful introduction of our organization. Thank you so much. Yes, I am Trey. I'm deaf, born and raised in a deaf family. I grew up in Alabama, graduated from the Alabama School for the Deaf, the state school here, and then went off to Gallaudet University, which is the only deaf and deaf hard of hearing university in the world, which is wonderful because it's accessible all in sign language. Graduated from there, moved over to India and worked there for a while in a program, came back to Alabama. I'm in grad school at the University of Alabama in Birmingham, getting my master's degree. So I've been working as a co-founder for this company, a copywriter and a co-founder of this company for some time now. So we'll hand it over to Ed to introduce yourself.
Thanks, Trey. I hadn't heard before that you had been in India. That's really cool. So I'm an attorney here in Birmingham, Alabama. This is my 30th year of practicing law, the past 20 of which I've primarily focused on representing people with disabilities, helping them enforce their civil rights. I have represented people with a whole host of different disabilities. I have represented people with hearing impairments in the past in particular, and have some experience with auxiliary aids and services for the deaf and hearing impaired, as well as for the blind. So all that said, I look forward to answering your questions and hope that this can be an interactive webinar. So by all means, if you have a question, please ask it.
Absolutely. Yes. Thank you, Ed. So we're going to focus on Title III, and that is regards to public accommodation. And maybe people are thinking for deaf and hard of hearing needs, if they have a request for a public accommodation, if you're a small business, how can people figure out what to do with public accommodations and provide for community members? I know maybe we know someone who had that taken away and weren't able to access something. How could we how can you help in those situations? So you've come to the right place. As a deaf individual, I understand. I'm asking it for a accommodation in a public event or something that's happening, and I'm unable to, and they say undue burden, financial reasons, or whatnot. So I'm torn because I want to know what that announcement is. I want to know what's going on, and I just want to know what is a way or different strategies that we can approach these businesses. So we're going to be asking Ed those questions. So if you have those questions about your community, you've come to the right place. But as audience members, feel free to ask any question. We have Ed here to answer. He's an ADA expert. If he's not sure of the answer, I'm sure he can find out, and he'll be able to answer you later. And after the webinar, if you have any questions, feel free to shoot us an email and he'll be able to answer that way as well. So we'll start off with a few questions that we have ready. And as audience members, if you want to clarify something or if you have a general question, please feel free to put it in the chat and I can ask your question for you. Or if you'd rather come on screen and sign or speak English, or whichever, feel free to do that as well. Okay.
And also, I will at the end close out with some resources and some of the things Trey was mentioning, email addresses and things like that as well. So we'll be sure to get some of that information out to everybody through a post email, follow-up email, and also in the chat tonight.
Cool.
Yes, thank you. Okay. So first question we have for you. So under the Title III of the ADA, it states that public accommodations are considered to be businesses that include private entities or anything that is open to the public that provide goods or services. I guess we wanted to ask if you could tell us a little bit more about these businesses and what that looks like for them. And each title obviously has its own nuance and area, but public accommodations is generally under Title III. So most people are aware of this one. So if you have any thoughts on that.
Yeah, it's actually not quite as clear as you might think it is. The ADA has a very broad and expansive view of a public accommodation, and the regulations define it by giving a whole host of examples, and really has tried to make it expansive. It's easier to define a public accommodation by telling you what it's not. so I'll do that. But before I answer that, it just brought to mind a recent situation. You know, I told you I've been practicing law for 30 years, and for the past 20, I've primarily been helping folks with disabilities. So my understanding of the way civil rights laws have evolved kind of come through the lens of the ADA and the Rehab Act and basically disability discrimination. And I had a very sweet lady call me who happened to be African American, and she was denied service at a hair salon on account of her race. She even described it to me as a white hair salon, and it never really dawned on me that there were, you know, white and black hair salons, but apparently that's a thing. And my knee-jerk reaction is, well, that's a public accommodation. I can't believe that they would be allowed to discriminate on the basis of race. That's got to be a civil rights violation. And clearly a beauty salon is specifically called out in one of the examples under the ADA of a public accommodation. But if you look at the original Civil Rights Act that was passed back in the 60s, a public accommodation is very, very narrowly defined as a restaurant, a place where you go to see a show, a place where you go to exercise. That's pretty much it. I mean, there's just very few. I don't have it in front of me, but it was like 3 or 4 things. And so the vast majority of what I think of as a public accommodation for ADA purposes, apparently you can still discriminate on the basis of race, and which was news to me. But in any event, what is not a public accommodation as far as the ADA is concerned? Those are called commercial facilities, and you'll see that term used. Now, can a public accommodation be a commercial facility? Well, yeah, almost all of them are. But there are commercial facilities that are not public accommodations. And generally, they're the type of places where you would not expect the public to want to go. So for example, you know, we all order things from Amazon and they're drop shipped to our house. Well, where are they drop shipped from? Some big warehouse somewhere where people work, picking orders, unloading trucks, loading trucks, and basically having goods come and go. Well, that's an example of a commercial facility. You know, we all get calls probably multiple times every day about our car warranty having expired. And at least I do. Maybe you're not on that call list, but I'm constantly getting calls about my car warranty. So where's that call coming from? It's probably coming from a call center where people are going to work to make phone calls, but a member of the public is likely not going to go there. You know, you might have an office of insurance underwriters, not insurance salesmen, but people actually determining what the terms of policy should be and what the premium should be. Those types of folks are not generally considered to be working in a public accommodation. So I hope that answers the question. If it's not a place where you would go to hire somebody or to buy something, then it's probably not a public accommodation. But practically everywhere else that you go to do those things is.
Can I interject and ask a question
Please.
very specifically about what you're saying right now?
Yeah.
Okay, yes, you wouldn't go to Amazon, it's a commercial facility, but then it would fall under another title. So you're just saying it wouldn't fall under public accommodation?
No, it does fall. Well, let's talk about that. A commercial facility does fall under Title III, just like a public accommodation does. But a commercial facility has a different burial removal responsibility than a public accommodation does. So, for example, if you work at the commercial facility or the public accommodation, like for example, say you work at Walmart. Well, Walmart's a public accommodation, and if a shopper with a disability went there, they would fall under Title III of the ADA. But if an employee with a disability works there, well, then they fall under Title I of the ADA. A commercial facility falls under Title III, but that whole section on readily achievable barrier removal, that is, you have an existing facility, an existing commercial facility that's been in operation for a long time before the ADA was passed, and it has all these architectural barriers that have not been removed. If it were a public accommodation, they would have the obligation to make modifications to remove those barriers, put in accessible parking, put in curb ramps, widen doors, make bathrooms accessible. If it's a commercial facility, they don't have that obligation.
Okay.
Only if it's newly constructed. So I hope that answers the question. But pretty much any place you can go, whether you're going to, your doctor's office, your lawyer's office, your accountant's office, your insurance salesman's office, offices generally covered, stores, restaurants, bars, gymnasiums, arenas, stadiums, music halls, barbershops, any kind of a service facility you would frequent, the spa, you're going to get your mani-pedi done, it's a public accommodation.
And so speaking of that, in that vein, there's a lot of different locations that do fall under Title III, absolutely. So are there some businesses that can not provide accommodations? And if so, who are they? Where they don't have to provide those public accommodations?
Yes. Well, to answer your question, at first I was going to just say no, but no, there actually are. There are two distinct exceptions to the ADA. One is a religious organization. Okay, so a church does not have to comply with the ADA. A church doesn't qualify, is exempt. So whether or not it's a public accommodation, I don't think it is, but even if it were considered a public accommodation, it's not covered. So if the church is operating a public accommodation out of the church, it's also not covered. So for example, the church owns a daycare and you want to drop your kids off at, the First Methodist or whatever daycare center that's operated by the church, it's not governed by the ADA. Similarly, private clubs. So that has to truly be a private club. There are a lot of things we think of as a club that anyone can join, and there's no membership criteria. Everybody can go to the Y and pay whatever it is as a guest and go in and use it, or join the Y. So the YMCA is not a private club. It's not exempt from the ADA. But if you actually had a private club where you had to apply for membership and they were selective, then they're not governed by the ADA. So a lot of country clubs, for example, come to mind. But apart from those two exceptions, everyone's covered. And it's important to know that it's possible for people to fall under that exception, but still have the same responsibility by another legal avenue. and that's the Rehabilitation Act. Section 504 of the Rehabilitation Act will require that a recipient of federal funds not discriminate in programs that are benefited by that federal funding. So for example, if you went to, say, a Baptist medical center, that's a hospital, it's owned by a religious organization, it's not covered by the ADA. But if they accept Medicare benefits, well, then you get the same accommodations, auxiliary aids and services by a different legal means. Basically, it would be equivalent to what you would get under Title II of the ADA, which is pretty much identical to the Rehab Act. Good question.
So any religious organization, you speak of that, and then any private clubs, those two you name, unless they're receiving any type of federal funds, then they're not responsible for providing public accommodations. Maybe you're headed to a church or synagogue or a temple of some sort, and there isn't anything there. We do have to keep in mind that they are not responsible for providing that. And if I were to go, let's say, to a dentist, any dentist office, and I ask, I need an interpreter as I'm a deaf patient, and they say no, can they say no? Sometimes they say they don't have the ability to provide public accommodations. Can businesses turn down that request for those public accommodations?
Well, yeah, they can, but there are consequences. There may be consequences. Let's put it that way. It depends on the person with a disability. Let me back up and say this. There are no ADA police, right? If we see somebody speeding down the highway in their car, we can get their license number and we can call the police and say, hey, there's somebody, I think he may be intoxicated or he's just driving really recklessly. And the police may investigate. They see that, they arrest that person because they violated the law. The ADA is a civil rights law, so the police don't enforce it. And there's really no one going around enforcing the ADA. In fact, the ADA charges people with disability. It actually empowers people with disabilities with the ability to enforce the law. So for example, if a hearing person witnessing somebody at the dentist's office being denied an interpreter such that they can't really convey the fact that they need a root canal or what have you, and they are forced to go somewhere else, the person who witnessed that can't do anything about it because that person doesn't have a disability and has no power to enforce the ADA. But the person with a disability who was denied absolutely does. And there are different methods by which you can do that. And I think of it as three options. The first option is self-advocacy. And you know, I hate to say it, but if you're a person with a disability or if you have a child with a disability, you're kind of always having to be educating the public about what should happen, you know, what you're entitled to, what your children, how your children should be treated at school, what have you. And so you can't ever, if you're a non-confrontational person, I imagine it would be a very difficult position to be in. I know I would hate to be in that position. I'm a lawyer and I'm a pretty non-confrontational person, but believe it or not. But all that said, that's the first thing you can do is to educate others and advocate on behalf of yourself. And the first step in doing that is understanding what your rights are. And so, yes, the answer is the CFR section. I think that Trey just sent it or somebody sent it that I sent. There's a link to the Code of Federal Regulations, and I have it up here. It is 28 CFR 36.303. And if you click on that link, you will, where did my Zoom go? Y'all still see me? Because I don't know where it went.
Yes, we can see you.
Okay, I can't see you guys. So anyway, that's weird. I just see the caption box. I'll figure out how to get this back in a second. But, oh, there it is. Okay. How do we make that big?
In the meantime, I'll send out that link again.
Yeah, no, it's like it's there, but it's like no longer visible. Oh, here it is. I got it back. Okay, so long story. I'm sorry for that. So, long story short, you know, there's a lot of materials that you can download from the ADA homepage. I'll give you another resource. It's easy. ada.gov. And if you go there, you can find all kinds of stuff. And there's probably a small little handout pamphlet that you could download about your right to effective communications, or a guide for small businesses to provide effective communications. There's the Title III Technical Assistance Manual. That has examples of what types of effective communication options a business would be required to provide.
But ironically, not an ASL.
Well, there you go. There you go. And so, yeah, there's one question that Trey had sent that I'm really itching for him to ask me, but it hasn't come up yet. But we'll get to it when it's asked. But that's the first step. Is first thing is, if you don't ask, you're not going to get it. So you know, I have had clients that go to a certain medical center for treatment, and they just expect, just as a matter of course, that an ASL interpreter is going to be for them there when they show up for their appointment, because it always has been in the past. And then they're in for a rude awakening when they go anywhere else in the state, and they don't get it. And so asking is really important. And so you have to then ask yourself this, as an attorney: do you want to go be treated by a dentist who won't hire an interpreter for you? Or if you decide you're going to take some steps to enforce the law, are you going to want to see that dentist after you've sued him? You want that guy poking around in your mouth after you filed a lawsuit and he's had to go hire an attorney to defend it, and then he's educated by his own lawyer that he screwed up and he should have provided an interpreter.
Right.
Or at the very least, engaged in the interactive process with his patient who was requesting an interpreter to gauge whether there was some other way to engage in effective communications. And that's the key, the interactive process. If someone is just dismissive and just says, no, you don't get anything, or we can't do that, or that's too expensive, and that's the end of the discussion, I think the ADA has clearly been violated. So yes, you can self-advocate. You're probably not gonna find anyone there on premises if you're dealing with unless, I guess, maybe in that example where you're dealing with the dentist himself. Maybe you do have the ear of the person you need, but generally I tell people to be business-like when they're dealing with a business. So find out who the owner is. You can write letters. You can provide those materials you can find on ada.gov. You can give them a deadline by which to change their policy or to create a policy, because chances are they don't even have one. They don't understand what the law requires, because you may be the first person that's ever asked. So barring that, if you don't get anywhere that way, the next step, the second option, would be to file an administrative complaint. And there are different administrative agencies that oversee the ADA in different settings. Generally, it's the Department of Justice. And at that ada.gov page, there's a link for you to file a complaint online. And so that's one way. If it happened at your university, then you could file it with the Office of Civil Rights with the Department of Education, as another example. So the third is you can file a lawsuit. And the thing to know about that, and I have had several cases where public accommodation has just refused to provide effective communications. And generally, I don't charge my clients for that. The ADA provides for prevailing party attorney's fees. So if you win your case, your lawyer gets paid by the person who discriminated against you. So you shouldn't have to come out of pocket to enforce your civil rights. And and I've had some pretty decent success. There are certain situations when you can recover damages for that, even although there's a recent Supreme Court case that has come out and pulled the rug out from under us on that issue. So I'm not so sure how easy it's going to be going forward, absent some special circumstances. But if anyone has questions about that, we can get into it. But those are your three options. Is self-advocate, file an administrative complaint, file a private lawsuit.
And adding one thing to that, that response, there we go. One thing with that response, if anyone needs to ask for a public accommodation, please be sure to put that in writing, because having that in writing is proof and documented that you did the legwork in making that request for that accommodation. That discussion that was had is saved, and you have proof. And there's proof that the law was broken. Maybe they did agree to it or they did not agree to it, but having all of that in writing that they refused to provide is proof and can support your case to make sure that you have that in writing is highly important, and that will help.
Excellent point, Trey.
Yeah. I just want to open it up to the audience if anyone has any questions or comments at this point, or if anyone wants to share any thoughts of what we've talked about so far with Ed.
Yeah, in the chat, or again, you're welcome to come on video. Don't be intimidated. You're welcome to share, something. Maybe it's not a formulated question, but just something that, if you're curious about, please feel free.
But at any time, yes, put that in the chat, whether it be now or anytime through this workshop. But there is one situation that Angelica has experienced, and so we wanted to hand that over for her to explain. Go ahead.
Yeah, so in my own work, I've worked in the last 10 or so years quite a bit in the medical setting, and in public accommodation across the board, like we were talking about before the hour started, there's so many gray areas to public accommodation, so many nuances that come up, and it just is so case by case, depending on how big the business is, depending on what services provided, depending on the severity of situation, et cetera, et cetera. But I, as an interpreter, witness quite a bit of things along the way, and especially in a hospital system. There was one hospital system where they had determined that staff, and I've seen this often in other medical settings, were deciding when a patient needed an interpreter. So their self-assessment, maybe a nurse or a nurse manager or whoever it might be, would come in when an inpatient was admitted, and they did an assessment. I don't know what that included, but that they said that was their policy. And they did an assessment of whether this person used American Sign Language, whether they needed an interpreter, and whether it should be on-site or VRI. And with those parameters, and the way they explained it to me, oftentimes we as interpreters will hear in the community, oh, this person just got admitted to the hospital. Well, the interpreter community is pretty small, so a lot of us tend to know if we're working in medical settings, whether or not we're going there or not, because in inpatient situations especially, oftentimes you have to get a team of interpreters going in and out. So we'll ask the hospital, hey, we heard that this person is admitted. We just want to be sure that they have effective communication during their stay, yada, yada, yada. That's when we get pushback, and they tell us that this is their policy and they have addressed whether or not an interpreter is needed. But there have been multiple occasions where we know for a fact that this deaf individual is not receiving effective communication, and that their first and preferred language is American Sign Language, and maybe neither getting on-site or VRI. So I am curious about your take on something like that, where their procedural approach is something of that nature, and what types of things. Yeah.
No, that's the question I was looking forward to. I don't know why I thought it was Trey's question, but yeah, no, I'm glad you asked. Okay, so, and I can go through and redact this so that you can share it. And also, to be totally candid, I would like to get the feedback from all of you and from the people who are attending who are interested in this topic as to whether maybe my proposed policy isn't all that. Maybe it could be better. And so, but I have a policy that I have used in the last couple of effective communication cases that I've had, that as a condition of the settlement, in addition to compensating my client for the emotional, anguish caused by not knowing what the doctors were telling her or him, that they also adopt this policy and train all their employees in it. And invariably what happens is, when I file a case like this, I'm told, oh, well, we have a policy. And then I say, well, great, well, send it to me so I can comment on it, and we can determine if it needs to be tweaked. And then I never get it. And then they're like, well, why don't you just tell us what you think our policy should be? I'm like, okay, I would love to do that. And so here's what I pulled it up. Let me see if I can do this without losing the window. Here we go. I think I did it, but we'll find out when I try and go back. Okay, so this is like Exhibit A, and I try and address what you've said, or what your concern is at the very beginning of this. Would you mind if I just read this policy to you?
Sure, go ahead.
Okay, so we're just going to say hospital. I can't name who the hospital was in this case. Hospital recognizes that it has a duty to provide auxiliary aids and services when necessary to ensure that communications with people who are deaf or hard of hearing is as effective as communication with others. And then I cite that CFR section that we've already provided a link to. Hospital also recognizes that auxiliary aids and services are often needed to provide safe and effective medical treatment. Without these auxiliary aids and services, medical staff run the grave risk of not understanding the patient's symptoms, misdiagnosing the patient's medical problem, and prescribing inadequate or even harmful treatment. Similarly, patients may not understand medical instructions and warnings or prescription guidelines. Nothing in this policy should pose an undue burden to hospital in the vast majority of patient communications. And should hospital believe undue burden may require alteration of this policy in a given unusual situation, hospital shall engage in the interactive process with the deaf or hard of hearing person to ensure that effective communications are provided without undue burden with reference to this policy to the greatest extent possible. This policy recognizes that the individual who is deaf or hard of hearing likely has experience with auxiliary aids and services to know which will achieve effective communication with his or her healthcare provider. And this policy requires hospital to consult with the person who is deaf or hard of hearing and to carefully consider his or her self-assessed communication needs before acquiring a particular auxiliary aid or service. And then I'm going to stop reading, but that's the key to me, is not just to find out what they want, but give it some weight, because that's the person who's in the best position to understand how they can best express themselves and how they can best understand what's being communicated to them.
But how are they being asked? That's my main concern.
And that's when we get into the meat, the real meat of your question is, even if your policy is to do that, how can you do it if you're not providing any auxiliary aid or service? And my answer to that question would be you can't. And I would say if they're not providing some auxiliary aid or service, now obviously it would make no sense to provide an ASL interpreter to a person who doesn't understand ASL. So I mean, that's not a one size fits all answer.
But Right, but what is the step then if a person who does not know anything about the deaf community or ASL, how are they supposed to know, oh, that is ASL, but that seems like not? And
Oh,
that's
they're not.
my issue with it, is that they are not qualified to even identify someone who maybe even says, oh, I know ASL, but who knows what that means? That could mean I know how to finger spell the alphabet.
Right.
It could mean a lot of different things, but that's why we defer to people who know the language and are professionals that can come in neutrally and decide, you know, what's happening, and then that could be the assessment. You know, but otherwise the policy is canceled out if in the beginning you can't even do that assessment to ensure
Yeah, you have
that
to
your
be able,
policy.
you
Yeah.
have to be able to communicate with the person at some, on some level, to be able to find out what their preference is. But here's the key that a lot of folks who prefer ASL interpreters don't fully understand, and that's this. If it's possible to communicate effectively with somebody who prefers an ASL interpreter but is fluent in English, written, spoken, whatever, then the public accommodation may be within their rights to not provide the ASL interpreter. And that's where you get into these splitting hair, the big gray area of how is anyone supposed to know how much that person is really understanding, swapping notes, if English is at best a second language for that person. And so, you know, I have no doubt that if we were swapping notes with Trey, that he would be fine with it, but he's probably less comfortable with that than with sign language. I don't want to speak for Trey, but that would be my expectation. And so I think that you have to give weight to what the person with the disability requests, how they self-assess themselves as to what they can and can't do. And I think it's very frequently when I've spoken with folks who have had issues in the medical setting, is they may be okay until they get to some of the medical terminology that's used. Or like you say, 80% may be fine for, going through the drive-through window, but it's not great when you're dealing with your cardiologist.
Yeah, and with an inpatient, and we don't need to continue too much longer on this question, but inpatient in particular, hearing people, I'll speak on hearing people because I know hearing people. Hearing people, they don't notice anything until all of a sudden hearing something is not right. So if I go to a concert and the sound isn't right, I can't hear the person who is the musician or, what you went there for. I went to the movies and the sound was distorted. They're up in arms. Give me my money back, And on top of that, we don't notice on a regular basis how often we're speaking and making comments and doing this and that. And when you're in an inpatient situation, you're having nurses come in constantly. You're having a medical assistant help with, checking blood pressure or, whatever. And that information would be relayed to a hearing patient. So why wouldn't it be relayed then to a deaf individual? And further on that, if, medical assistants, nurses, so on and so forth, knew that they needed to make sure in another way visually to let the deaf patient know this what was happening. I just took your, blood pressure and this is what it is. That would be maybe another story. Maybe it would be effective, but at the end of the day, hearing people don't realize how often they're talking or what they're doing and what is being conveyed through communication. And again, especially in an inpatient situation, very specific to that, there's communication from start to finish. There's always something happening at some point. And so very specifically, again, inpatient, that's why I was asking that question. That's why I don't think any hearing person who is not fluent in ASL really has the perspective or expertise to be able to really assess that situation.
So you would recommend that the policy that I wrote actually require that the person who is doing the assessment be an ASL interpreter?
Yeah, or a parallel, professional of the like, maybe it is someone who is proficient in ASL, but has some expertise that they're able to find and locate, and they just do the assessments, and that's what they do. From city to city, I'm sure it would be different, but yeah, I think an ASL interpreter would suffice. And I think at minimum, you would have the communication or not happening, and that would tell the hearing nurse or whoever is the staff everything. I think they would need to know. And I don't know if Trey saw this, but somebody in the audience said, or at minimum VRI for initial assessment. I agree as well. That could be a very minimum type of approach as well.
I would be surprised if they not
Yeah.
use VRI for that purpose, because most hospitals now have that. I mean, initially when I first started doing this work 20 years ago, they didn't even have that. But now it's kind of a double-edged sword. It's like now that they have that, that's all they ever want to use, and it's not always effective.
Or staff doesn't realize it's there, or they don't know how to use it, or they don't know that they should. And when you're even a warm body interpreter standing there, you at least have the initiation, I guess you could say, to assess the environment, or to assess what's, the dynamics of what's happening in that environment, and to professionally prompt, other medical professionals that you're working with, as I could say coworkers, to say, hey, this is what I do, and I'm just going to lead you into this because you're not your area. I'm not a nurse, you're not an interpreter, that thing. Like, I'm going to just kind of lead us along the way, and a VRI machine, unfortunately wouldn't do that. But if people around knew, okay, right now we needed to do this, and we need to make sure the picture is clear, let's start the assessment. Oh, I've noticed that the interpreter is blurry. This isn't working. Let's get another interpreter in. But unfortunately, nursing staff, medical staff, they don't know the nuances of that. So I think that's where it falls short as well.
Absolutely. I know someone was taken into the hospital. They were on a stretcher, went into the hospital. They wheeled in the VRI. There were issues with the screen, and that it's on a pole and the person is laying on their back looking up. And it was very difficult for them to follow and see the VRI screen. Plus, they were on different medicines and drugs that made them dizzy. And it was very difficult for them to see. And it wasn't accessible with the where their eyes were, because they were looking up. So luckily, we were already there. I was already there to support with that. But if I wasn't, what would we do in that situation? As Angelica's saying, we see in a lot of situations that this does happen. With that, you say, if maybe they would go in and you want a live interpreter to come into the room. And typically hospitals will say VRI qualifies as a reasonable accommodation. This should do. And you put up an argument that you want a live interpreter, and they still insist that the VRI is sufficient. I guess, what can we do? I mean, legally, is that a reasonable accommodation, or do I still have an opportunity to continue to fight for a live interpreter? What should I do in that situation?
That's a great question, Trey. And if you don't feel the communication is effective, if you don't feel you're being understood, if you don't understand or feel that you're not understanding everything that's coming at you through the VRI machine, then it's not effective. And if they're not providing effective communications, then they're not complying with the ADA. So the problem that you have being in that situation as a deaf person, being given a VRI accommodation and being dissatisfied with it, is proving that it was not effective. And so I had this situation with a client, and the expert that I had hired made the recommendation to me and the client when we were having a conference that when you're there and you're being and they're getting the VRI machine out, and they're trying to figure out how to work it, and they're having problems. That's when you should take out your phone and start recording it and document the fact. Take a video, document the fact that the screen was blurry, or that from where you were on the bed you couldn't see the screen, or whatever, or that it just wasn't working, that the there was some glitch, because a lot of times these machines don't work. The last case I had, the VRI machine stayed out in the hallway the whole time because they couldn't ever get it to work. Whether it was a malfunction with the machine or because the nurses didn't know how to operate it, he never knew. He just knew that it didn't work. In that case, the hospital didn't dispute the fact that the VRI didn't work, and they apologized, and they admitted that they should have hired an interpreter. But I do have later on in that policy, I stopped reading it, but it goes on, and it very clearly states that VRI is only to be used as in emergencies. Somebody just comes in unexpectedly and there is no interpreter there. That's the situation when you use a VRI, because it's all you got. But apart from that, it really doesn't serve much of a purpose, and perhaps maybe doing those initial evaluations.
Yeah, I'd love to workshop with you sometime, because that really, that situation pops up often, and I think it could be effective if it's in a policy like that. Right.
And so that's what I'm trying to do with the policy that I'm floating out. And the last 2 times I've used that policy, they've accepted it. Now, whether or not they follow it, I don't know. But they've agreed that, yeah, that makes sense. We will only use VRI in emergencies and when we can't get a live interpreter. But I will add that perhaps it would be a good tool for doing the initial evaluation.
And speaking of that type of situation, so who technically is responsible for providing that effective communication? The consumer or the public provider?
The public provider. The public accommodation is required to provide the effective communications. I mean, you don't have any obligation as a person with a hearing impairment to come out of pocket for your own accommodation. It's in fact, it even says, in the ADA that surcharges on accessibility are a violation of the law. So, like, you can't charge somebody to use an accessible bathroom and let able-bodied people use the inaccessible bathroom at no charge, right? You can't, just like the relay service on our telephone, we all pay, they call it, unfortunately, they call it a deaf tax, but we all pay on our phone bill for the relay service. That's there because everybody shares in that expense. Mm-hmm. It's not just people who are deaf that have to pay. And so it wouldn't be right for the person with a disability to be charged. I had a case like that where they tried to charge my client more money to rent an accessible porta potty at a campground as opposed to what the typical porta potty rent. And every time she asked why that was, I gave her a different excuse. And so, yeah, we got her that money back, and they have a new policy now. But
do people think that they're just going around renting their own accessible bathroom everywhere? That would be an astronomical price.
Right. But, the people who opponents of the ADA call it an unfunded mandate. Why should this business have to come out of pocket to hire the interpreter or to, restripe their parking lot or build ramps or what have you? It's not inexpensive, but there are tax credits that you get for incurring those expenses. Now, exactly how that falls in line with, the periodic need to hire an interpreter, I would guess that would qualify for a tax credit.
It does.
So I mean, so when people make that argument, that's another little piece of self-advocacy that you can give them. Is like, as a matter of fact, it's not just a deduction. It's not like you're just getting to deduct this. It's a credit. I mean, you're getting tax dollars paid by hiring that interpreter. Doesn't really cost you. Of course, the credit is 50 cents on the dollar after the first, I think, $500, but still, whatever they actually pay, it really only costs them half that.
Yeah, and I think that people view it as an unexpected cost, but it really is just a in the moment sort of direct cost, whereas you're talking about FCC taxes or a lot of things that we already pay into that we just don't think about that are maybe seems
Right.
a little bit more indirect. There's tons of things that are required of businesses and individuals for that matter, and we just have to pay them, or we just have to do that because that's the society that we're a part of.
Right.
But I can understand as a business, you know, being surprised by that and realizing what the cost is. But at the end of the day, we're all participating in this society that is diverse, and we need to make sure we're all included in it.
Yeah, and you know, a business can't, just the fact that they have to come out of pocket is not a defense. It has to be unduly burdensome. And so, you know, if at the end of the day, the cost of the interpreter is significantly more than the revenue generated by that customer, perhaps maybe that is unduly burdensome. But if you're there incurring a, you know, you're buying a $30,000 car, or you're in the hospital, you're hospitalized at God knows how many thousands of dollars a day, it's a drop in the bucket. So I don't think it could ever be found to be unduly burdensome in those situations. But yeah, if you're picking up your $4 prescription and you have a question, do you have a right to effective communication? Absolutely. But if it's possible to do it without the pharmacy having to come out of pocket for an interpreter, then, you know, perhaps that would be the way the pharmacy would choose when there's just $4 at stake, if that makes sense. I don't think you can look at it divorced of the economics of the situation.
Wonderful. Yeah, thank you for thoroughly explaining that. Thank you. Yeah. In society's not designed for disabled communities, so we're trying to point out where they're always ready to try to find where the accommodations should be. We're trying to hopefully rely on the law that can get us what we need in terms of accommodations, but we're just trying to make do. But just opening it up again, if there's any audience questions, comments, thoughts to share, and then I'll hand it over to Angelica to close.
Yeah, again, we'd love it if anybody wanted to come on, and please, you know, add any more comments or questions. We can give it another moment and close.
Oh, the question about the timeline. So
do you want to
yeah.
name,
Chris,
do you want to name the question? Because I don't think it was.
Yeah, here's the question. The question was, if a person files an administrative complaint about you know, an ADA violation, what's the typical timeline to hear back? And the answer is it varies greatly, and I would say that the pandemic has not helped at all with regard to the responsiveness of our federal government to administrative complaints. So historically, pre-pandemic, it would be unusual if you went online to ada.gov. In my experience, and I've helped many people do this, and I've had many people come to me in frustration after having done it and not heard anything for a while, that you're not going to hear anything for, you know, at least 30 days. You might not hear anything for 2 or 3 months. Now, that being said, I have found that the Office of Civil Rights with the Department of Education is extremely responsive, and that you would probably hear something from them within 30 days for sure. And they would likely follow up with you. Same thing is true of the Equal Employment Opportunity Commission for employment-related discrimination. They're horribly backlogged, and trying to get in to talk with them is a process that takes months. But once you get through that point, they're very responsive, generally. A couple of anecdotes about the DOJ, which is who DOJ and OCR, where I had the most experience, is that DOJ historically would refer the complainant and the respondent, the people that were complaining about, to a third-party mediation company in Maryland to try and set up a telephone conference to resolve the dispute in that way. Every once in a blue moon, they might go out and investigate. You know, if this is something that lots of people are complaining about. And I remember I was filing cases in the early 2000s against Greyhound bus stations because the stations themselves were not accessible. And I had, I don't know, several of them in several states, from Florida to Washington State. I had several of these pending. And I got a call from the Department of Justice wanting to know if I had any claims about, you know, service animal discrimination, discrimination of bus drivers, not allowing people to get off the bus and all of this kind of stuff, because they were in the process of investigating that for bringing a big case, which they subsequently brought. I did have one case where a lady came to me after not hearing anything for about a month after she and her son were kicked out of a mall with their service dog. It's a diabetic scent dog, was escorted off by the security. And so I took that case on, wrote a demand letter, was in negotiations, getting close to getting the case resolved, when I got a call from the United States Attorney for the state where this happened, saying, your client told me to call you after I called them, because we just got from DOJ the administrative complaint they had filed, and we were gonna actually file this case for her. But if you're already doing that, we'll stand back and see how it turns out. So things can happen. So I would recommend, if for no other reason, you're creating a public record that this happened at this facility. And if everybody who's discriminated against put the government on notice of where and when this was happening, I think that it would be more responsive, and the places that are affecting a large number of people are obviously going to get addressed first. But yeah, I think there's definitely merit to doing it. I don't know that it necessarily resolves a lot of claims, to be totally candid. But it certainly doesn't hurt, and you can get attention. I have seen success stories. So I hope that answers your question. But if you're expecting you'll file that complaint and then somebody from the federal government's going to go talk to the dentist to use Trey's example, that's never going to happen with an administrative complaint. No, that's not going to happen.
Yeah, it seems almost that when suits are filed, the more suits you can refer to, just makes the ADA stronger. But otherwise, I personally don't see a lot of effective change unless you go to a business and you get the right person, right position, right attitude, and they make things happen, and then it's great. But then someone's replaced or something changes, and then oftentimes that falls through. So I do think, for my own, work, that a lot of times policy change and lawsuits, unfortunately, a lot of times really do create the impact that's needed.
Yeah, I would say probably 1% of the disabilities community does the advocacy for the other 99%. It takes folks who are willing to step forward and say this is wrong and it needs to change, and are not afraid to have their name out there on a complaint to affect change.
Yeah. Well, I'll ask again if there's any last questions, or again, you're welcome to email us afterwards as well. We put our email addresses in the chat, but we'll also follow up with an email with all this information that we, put out some links and some other info for everybody, so you don't have to write it down right now. But we'll also, I wanted to put out some resources too. Ed had shared something earlier, and we'll put that back out there again if you wanted to click on it. I had found something when I was going over some information about small businesses with the ADA, and then ADA Title III had some information as well, this website that I found. Also, we wanted to put out a survey. We put this out every time just to get a pulse on how things went in this webinar. What would you like to see for next time? Was something inaccessible? Want to make it better, whatever it might be, or maybe you click great, everything's good. That's good to know too. And then if you visit our website, I encourage you, just so you can see it, to have all of the videos that we have on there and all of the work that we put into recording a lot of deaf interpreters in our community, investing into the deaf ecosystem and hiring them, but also just having that as an accessible website. You don't see that very often, and we're really proud to show that. But also, if you want to subscribe to our newsletter, we send out a blurb here and there. We also update about any event that we're doing in the future. So go ahead and subscribe to that. I don't think there's anything else unless you had any last minute thoughts, Trey or Ed.
Yeah, I just want to thank you all for coming. I hope everyone learned something new. And if you still want to ask some questions, I know we ran out of time, you can reach out to us. You can reach out to Ed directly at any time. We're here to support you all. And our next ADA Q&A session will be on June 1st. Same time, 6 to 7 through 7:30 through Zoom, and we'll send that information out soon. And thank you again for attending. Ed, did you want to add any last minute thoughts or advice?
Oh, just thanks for including me. I enjoyed it.
Thank you so much.